Good morning, everyone. Thank you so much for joining us today. I am Charlotte from PropAcademy. I've been with PropAcademy since February 2023, and I am a sales representative here. I will be your host in today's session, and joining us is Marizelle and Alison from SBL Attorneys. So thank you both so much for being here today. We really appreciate your time, and we are very excited for today's session. If you both want to just introduce yourselves, and then we can move into the questions.
Perfect. Thank you so much. Thank you, Charlotte. Thank you, Courtney. So I am Marizelle Kutter. I am the HR and Marketing Manager at SBL Incorporated, currently based in our Cape Town branch. So it's amazing to see some agents from the Western Cape joining us today. Thank you so much. So where my passion for property also come from is I was a real estate agent myself before joining SBL for quite a few years, working in the field, knowing what it is to be an actual agent, having that hardcore discussions with landlords and tenants, and knowing exactly how to bring in POPI to make sure that you are compliant when being in the field with both landlord and tenant and as a property practitioner. So yeah, that is just in short who I am, but I'm very excited to share some insight with you today. Thank you.
Well, hi everyone. My name is Alison Laxton. I'm an associate attorney at SBL, and I joined them last year. I have an interesting background, so I've been in practice and academia and also done internal legal advisory. And yeah, I'm just hoping that you can learn some nice compliance nuggets today. POPI, we're going to try and make it exciting and clarify it because it's quite a daunting area of law.
Amazing. Alison, Marizelle, thank you so much. Courtney, do you want to do a short introduction?
Yeah, sure. My name is Courtney McKenna. I represent PropAcademy, which is your online training institution. We developed this business right from the beginning because there was a huge gap in the market for online training. So I'm pretty sure we've nailed it. And you can see that by our amazing audience. So thanks to all our learners for joining. It's really beneficial for you to continue to come to these. And I have mentioned, but I'll say it again because we've let in a lot of people over the duration to just let me know, how do you feel about the webinar? What other concerns does your office have that we could actually use as a topic for our next one? So let us know, don't be shy. And if you prefer to private message me, I'll pop my number on the chat as well. Thank you so much. Over to you, Charlotte.
Wonderful. Thank you all so much. Alison, we're going to get started today with a question for you. So we're going to start at the very beginning. What exactly is the POPI Act and why does it apply to landlords and estate agents in the first place?
Great. So I think POPI is something that people were not aware of until 2021. It's been around since 2013. It's the Personal Information Protection Act. So ultimately what it aims to do is protect data subjects' personal information and how that is used and stored and destroyed and processed. And essentially it comes from a wide body of international legislation. So your GDPR protection in Europe, they've got a lot of information privacy laws, US as well. And it's really a very important piece of legislation. Now, it's been around, like I said, since 2013. In 2021, certain provisions came in and the information regulator was established. And that's when everybody panicked and every WhatsApp group you were on sent out a disclaimer and everyone sent out an email and suddenly people became aware of POPI. But POPI cannot be read alone. It interacts with another piece of legislation called PAIA, and that is PAIA. That is the Promotion of Access to Information Act. And the two of them are husband and wife. So just like we want to protect your personal information, we also want to make sure that we give people access to information that they should have access to. So I just want to speak to why it's relevant, if I can quickly, for the industry, Charlotte. And if you are handling as a managing agent, as a trustee, as a landlord, if you are handling someone's personal information, whether it be for the sale of a property, for a mandate, for finding a tenant for a lease agreement, that is somebody's personal information, and you are a responsible party, or you're going to be called a service provider, because you are taking personal information from that data subject that is identifiable information, right? So it could be ID numbers, it could be full names, it could be marital statuses, all that sort of stuff. And that's why it's important to know how to be POPI compliant, because if you have a data breach, you're going to be in trouble with the information regulator. So that's why we're having this webinar today. It's not something that just applies to corporate bodies and to, you know, large banks or people who think they only work in fancy firms. It applies to any person who has personal information, that's everybody here, and any person who is storing, collecting, processing that personal information. So it's hugely widely applicable, and especially in the industry as well.
Amazing, Alison. Thank you so much. That makes a lot of sense. So Marizel, since the POPI Act is all about protecting personal information, can you walk us through what kind of data we're talking about? What type of tenant or rental applicant information falls under the personal or special personal information that needs extra protection?
Awesome. Thank you, Charlotte. Before I actually answer my question, I just want to say Alison is very humble when it comes to her knowledge about POPI and compliance, but she's absolutely a guru. So I want you to really just grab a pen and paper and make notes, because Alison is obviously very knowledgeable when it comes to compliance. So to answer that question, I want to tie in with exactly what Alison said. So if you think of POPI and information, it's anything that can pinpoint you in the direction of someone's identity. So we should now understand and bring it back to rental agents and property practitioners, as we currently name ourselves. And that is any data that you would use to run a rental application. So it all starts at the rental application, where you gather some information from your tenants. So, for example, and please make notes as well on your side, just to have it on hand next time. It is any identification or contact details. For example, the tenant's full name, ID number, email address, even where you ask for their work address or postal address, anything like that. Secondly, it is obviously the proof where they live. So any municipal accounts, utility accounts, those sorts of things. Then employment and financial information. So here it gets very critical that you really handle that with so much care, because it's obviously their credit footprint. So any credit reports that you might run, their scores, and even the landlord references that they share with you. Obviously, they share it with you in confidentiality because that is what you ask for, but you're not allowed now to go and contact that landlord as marketing for your agency, if you get what I'm saying. And then obviously, lastly, also any references that they give you. So the employment reference, for example. So you should really handle that with so much care. And then if we take a step further, so especially the personal information and the financial and the credit side of things, that should be handled very more sensitive with the POPI compliance. And I want to break it down by saying, obviously, when you're, and I will get to that now too, but when you ask for an application to be filled in, it's obvious that they will give you the information, like their general personal information. But once they submit any supporting documents, that is where it becomes your responsibility as a property practitioner to make sure that you really safeguard those documents, because they entrust you as the property practitioner to handle it with care.
Okay, lovely. Thank you. So now we kind of know what data we are handling. We're moving into a bit of a longer question now, so please bear with me. What we want to find out is, when does consent actually come into the picture? When do landlords and tenants actually need to get the permission to process the information, and what does that valid consent actually look like?
That's a very important question. Thank you, Charlotte. And I remember when I worked in the industry, at first, before POPI was a buzzword, it was kind of like nonchalant, you know, like you gather the application form and you deal with the information and then you just throw it in a file at your desk and you hope for the best whenever that is. But the moment POPI became a buzzword, consent then meant the proper proclaimed yes from a tenant for you to process their personal information. Now, I want us all to really just quickly switch on our common sense here. Whenever a tenant obviously fills in an application form, it is kind of obvious that they give you permission to use their information because they actually fill it in. And that is why it's still cool to use an application form by hand. And, you know, digital ones are cool, but it can be someone else that fills it in for you as the applicant. So by hand is always very much authentic. But okay, let's use both scenarios. So you can argue that when you get an application form from a tenant, you don't always need to have the proper consent. But for you as a property practitioner to stay on the safe side, I would recommend from a compliance perspective, at the end, before you ask for their signature, to add a short paragraph stating what you're going to use this information for. Explain it to them. There doesn't necessarily have to be a tick box or a correction mark that they need to give, but it would be nice just for you to know that you've covered all ends of your process, your application process. So that is firstly, to break it down, you don't necessarily always need consent, but just to stay on the safe side, it's good to have a paragraph before you ask for the signatures. Now, take it a step further. When you ask for any sensitive information, health checks or biometric access, and you know that you need to share those information with a third party, like a body corporate or even with the landlord, it's very important to note it in your application form. Also, again, before the signature, for the client or the applicant then to read it before they actually sign the document. And there you can have a checkbox for them to tick to say, I agree that you can share it. Now, when you ask an applicant to apply for a property or you share it with them, tell them that this application is conditional to them obviously opting in. So if they fail to opt in to give you permission, obviously what are you going to do? Then you can't give them access, biometric access. You need to share the information with the landlord. So tell them as you send the application form to them, listen, this is conditional. You need to opt in for me to process your application so that I can share it with third parties, but I promise it's only going to be shared the necessary information for them to process it or whatever the case is. Now, you also asked about direct marketing. So direct marketing is quite a different ball game, but it ties in very closely. So obviously with direct marketing, you have to have a proper opt-in and opt-out option. So again, you can have it on your application form, for example, where you have another tick box to say, would you like to receive marketing material, promotional material? We all know that clause or that statement or sentence. So it's important for you to have that. Now, obviously, when you become an automatic client of a company or a real estate agency or the tenant or the landlord, make sure that you have those records of the people opting in. But always, doesn't matter what you send out, whether it's an SMS, an email, a newsletter, it doesn't matter. You always need to have an opt-out option. People always need to be able to opt out from any type of promotional material that you use. But remember, whenever a client or a tenant gives you landlord references to do reference checks, you are not allowed to use that contact information of that referenced landlord to send your marketing material to. That is 100% against compliance, and you can really get in big trouble for that.
Okay, perfect. Thank you. Now, that definitely gives us a lot of insight into the consent of it all. Alison, the next question is for you. Sometimes we find with application forms, they're asking for a lot of information. How can landlords and agents make sure that they're collecting only what's necessary and they're not holding onto the data any longer than they should?
So this is what a lot of people don't realize is it's not just what you're collecting, but Section 10 of the POPI Act speaks to the principle of minimality, which means only collect what is adequate and what is relevant. Okay, so it cannot be excessive for the purposes of what you are needing. So when you are assessing rental applications, for example, or managing leases, or you are concluding a sale, obviously you need to collect certain personal information, and you need to make sure the person is creditworthy and that they can afford the lease, for example, but you don't want to go and collect unnecessary information. So it's going to depend on your property. If this person is asked for things like medical history or their political views or something that is not relevant to the purpose of the transaction, and you are holding on to that information and sharing it or not keeping it safe, then it's going to be an issue. So obviously, let's think about rental applications for an assisted living facility for elderly people. They can ask about medical history because they need to know if you can live on your own or if you need to be in the frail care, okay? But most young 20, 30-year-olds applying for rentals don't need to give such in-depth information unless it's going to materially affect the transaction that you are vetting them for. So just an important thing there is to please not collect all the information under the sun, because should that information get leaked and compromise the data subject in any way, the information regulator can hold you liable. And that's a very important thing. The information regulator, although it is newly established, it has only been around a couple of years, they've started to flex those muscles and impose fines and penalties, and they will do audits as well of your POPI compliance. So if you don't think it's necessary, go and review your forms. If there's something on there that you feel is quite personal and something like medical history that's actually not required, then just remove it. You don't need that excessive information. Also, if you are asking someone for optional information, please mark it as optional and give them the, clear guidance on the form that if they don't want to disclose that, they don't have to. So I think also, besides POPI, we also need to be fair in our rental practices. So make sure that your forms do not allow for any sort of discrimination when you are collecting this personal information as well. So please remember Section 14, as we've said, how long do you keep this for? If you have actually concluded a contract, I believe the PPRA speaks to 5 years, and I speak under correction there, but they have their own timelines for how long you need to keep evidence of those contracts, and that's one thing. But if this is just an applicant, please don't keep that information for longer than 3 or 6 months, and make sure that you dispose of it and destroy it correctly, okay? Putting it in the recycle bin on your Google Drive is not properly destroying that personal information. So if you don't know how to have a proper data retention and destruction policy, obviously, as a consultant attorney can assist you with that, because you have to look at your business processes and customize it according to that. And also remember your storage systems, okay? We're moving away from pen and paper, and in a way that's nice and helpful, but it's also terrifying because most stuff is stored on a cloud. And if your cloud is not secure, you can have massive data breaches. Okay, so there have been credit bureaus where they have had data breaches, and you can imagine the amount of sensitive information that got leaked from those data breaches. So just to speak to your question there, Charlotte, I think the takeaway is only collect what's necessary, and make sure that you actually have a policy and a framework in place for what you collect, what is necessary and what is optional, and then of course how you store that securely and destroy it. And remember, you must make the data subject aware. Okay, so data subjects have the right to various things under POPI, and it's all to protect their information. So if someone says to you, please delete my email. I don't want to get your marketing anymore. You need to respect that, okay? Otherwise, they can go and lodge a complaint, and call centers are so guilty of this. Like, that's why we all have Truecaller, because they clearly don't follow POPI, and they don't respect the direct marketing provisions of the CPA, the Consumer Protection Act. But I think that's the takeaway is don't collect and abuse that information. Even if you think it's harmless, sending out a broadcast for marketing, like Marisol has said, consent is so important, and don't keep that person's email for 10, 20 years if you don't need it.
I just have a question, Alison. Thanks so much for all of that. It always takes me back to when I was an agent, which is bittersweet. So I wanted to ask, first of all, I thought it's quite nice on the application form for agencies to include an optional information, because that's kind of like, if you wanted the job, what extra would you tell us about you? They're not optionally going to tell you bad things. So I quite like that idea that this is a good to have, and a lot of landlords ask us as the agent about this quality of a tenant. So that can fall under optional, but everything that's compulsory, like you really do need it in order to run the application, is compulsory to complete. So thanks for that tip. And then the other thing I wanted to ask is, when I was an agent, I would always have like the tenant application form, and you say we would put them in a file. You're an attorney, we're agents, we throw them in a box. So with that information, when I secured the lease, for example, I would always keep the application form for that whole duration of the lease. Okay, so that's fine. All right, because sometimes the landlord goes, but you didn't make me aware that this person worked at whatever, and then on the application form you obviously have all the proof that you need to stand. Okay, thank you.
So I think what's important here is, if you are simply collecting tenant information and you don't actually place that tenant, and 3 to 6 months have passed and that application wasn't accepted by your landlord, or you're not actually going to work with that tenant again because they were super dodgy and you're not willing to place them with any of your clients, for example, then just make sure that you delete that information securely after 3 to 6 months. But also something else, and I just want to raise this because we actually have had tenants come back and say, but you never got my consent. When you do a credit check, please just make sure on your application form that you get explicit written, signed consent from the tenant, and you tell them that I'm going to do a credit check, and it will come up on your credit record, because credit checks can affect your credit record if you have more than a certain amount in a certain time. So I'm just speaking from my National Credit Act background here, but it does impact your credit score. So sometimes tenants will be irritated with you and say, you never actually got my consent. And I think that's why it's important to make sure that your forms are reviewed by someone who's a specialist in these pieces of legislation, because you don't want what you collect to come back and bite you. And the biggest area of contention is somebody's credit record.
That's
amazing.
Awesome.
Thank you both so much. So I think we pretty much covered the next question. I'll just ask it again now, just if there's anything more to add. Otherwise, we can move straight on. But Alison, what practical steps should property managers take to protect these records, whether they're stored in files, emails, or on any cloud systems?
Of course, I think so many people here are sitting thinking, I don't even know what our POPI policy is. You don't even have a manual. Like, you've got a PIA manual that ChatGPT did for you and you put it on your website, and that was like the last time you thought about any of this legislation. And I think what is important is to start with your framework, right? And your framework needs to be business specific, agency specific. No agency is identical to the next. And that's why POPI is flippin' confusing, because I can't tell you this is step A, B, and C. You actually need someone with expertise to come in, like a business analyst would do, and actually see how the different wheels of the engine turn together in your business. So how does a lead become a sale or a tenant, and where is that stored, and how are accounts handled, and where do you archive your things? Where do you store them? Is it online? Is it paper-based? It completely depends on your business. So that's the first thing. Start with a solid compliance framework where you have policies, and we'll speak to those later on, but you need to have a solid manual for what do you actually do and how do you uphold POPI as well. And remember, the information regulator at any time can come knocking on your door and say, right, we want to inspect your POPI compliance, and we want to see your policies, and we want to see how you uphold POPI. And you don't want that day to come. So rather make sure that you prepare for it in advance. I just also want to speak to security safeguards. So many people do not realize that people have access to information in an organization who shouldn't have access. So make sure if you're using a cloud-based system or if you're using a lock and key physical system, that certain people have access and that you actually can track who has accessed what at what time. And the reason I'm saying this is because, guys, phishing emails, like so many people fall for them, where Gmail 1234 emails your employee and says, hi, I am your CEO, please send me your WhatsApp number. And then they get into your whole system and you have a massive data breach. Okay, remember, data is valuable. That is valuable information that can be sold and is sold, and can be really risky for your data subjects in your company from a reputational perspective. So please make sure that you safeguard who has access, and this is where you're going to get a qualified IT team or a chief information officer in who's going to say, these are the technological safeguards that we put. If you have a restricted access room with files, do you have biometric access? Can we sign in and out of there? Because so often these things are just not properly protected, and not everybody should have access to these personal records or to databases in your company. So that is very, very important. People do not take encryption seriously enough. They don't take strong passwords seriously enough. We recently I attended a seminar where we had a fantastic speech from one of the banks on fraud. And it was just mind-boggling, the data that came out of there as to how easy it is for hackers to get into your system. And that's a big risk with POPI. So just make sure that besides everything else I've said, you actually have a qualified IT team. And yes, I know they are expensive. But you need to have them come in and actually assess the weak points, and know the downloadable free antivirus is just not going to cut it in this instance.
And I think it's quite funny, like when you started the webinar, you're kind of asking yourself, well, why is this so important? It's somebody's number or whatever the case is. But then I'm absolutely the same person who's like, excuse me, what gave you the right to phone me? So
100%.
They obviously want my number.
100%. And we've seen it where these things get leaked and people are then victims of identity fraud. And recently, had someone who lost his wallet on an airplane 9 months ago with his ID and driver's license, and then suddenly a PEP credit card was opened under his name. And whoever was at the airport who found the wallet clearly did not comply with POPI either, because how did they get hold of all the personal information? Right? So either someone who works at the airport's got a PEP credit card, or they just were not protecting that information closely enough. And remember, you have scanned documents for client applications. Like, it is so easy now for fraudsters to access that information and breach that data and use it with ulterior motives. So I think we don't think of POPI as serious until these things actually happen. And that's exactly what the Act is aiming to protect against.
Well, that is very scary, but very great to know. So thank you so much. And that actually leads perfectly into my next question. So Marizel, because property managers often share tenant information, whether it's with credit bureaus, contractors, or body corporates, what is the right way to handle this data sharing so that everyone stays compliant with the POPI Act?
Yeah, thank you, Charlotte. I think we were laughing now, Shane, the poor guy that lost his wallet at the airport. We really laugh now because it's actually it's so devastating to know that just in the blink of an eye, you have a replica of yourself out there opening credit cards on your name, and your livelihood is in jeopardy because of that. And that is exactly why it's so important for you as a property practitioner to make sure if you share any data with a third party, whether it's a contractor, a body corporate, an estate manager, if you're obviously placing a tenant in an estate and there's biometrics and a lifestyle center, for example, that you as the person who collected the data, make sure that the person that you share it with is equally sensitive when they protect the data, as good as you do. So things that you can put in place is, for example, to make sure that you have proper contracts in place, your SLA, your NDAs, make sure there's a POPI compliance section and a clause protecting both parties, for example. Another check that you can do is to obviously ask for proof that the service provider is POPI compliance. They should have their manual, they should have their checks ready, their checks and balances to say that they are POPI compliant. And you are allowed to ask for those things before sharing the information. And then lastly, again, I want to tie in with what Ali said, is just share what is necessary. Don't share the whole file, don't share the Google Drive file with all the folders and attachments and everything inside. Just share what is necessary with either the estate manager, the body corporate, the contractor, even the landlord. And again, if you share any data with your landlord, purely because they're the owner of the property, you have to explain to them the consequences if that data is being leaked, so that he also understands. Because in the end, and we'll get to that in the next questions, in the end, if that data leaks, it will all point back to you as the property practitioner who collected the data in the first place.
Definitely. Like, I know this sounds like a lot of work that we need to remember, but we can see how vital and necessary it is to have all the information stored correctly. What actually happens though if someone doesn't comply? So can you explain the kind of penalties or risk that a landlord or agencies might face if they ignore the POPI requirements?
Yeah, so as Ali said, also the regulator came on board around 2020, and that is where they firstly put in place, and I think that scared everyone, but it's a scare for the good reason. Before I get to that, I just want to give a definition of what happens or what it means when data is getting leaked. So that means when data that you collected as the property practitioner from your tenant gets into the hands of someone that's not allowed to have access to that data. That's it. And you can first be fined, and I mean that fines can range from 1 million rand to 10 million rand. It can become criminal penalties, and it can even become a civil procedure where you, as the property practitioner, will have a court case against your name from the tenant who might have had any damages done to his personal identity because of the data that is being leaked. Similar to the guy at the airport, although it's not a rental scenario, but I mean, he most probably opened a case if he was able to track down who that person might have been. So that is quite heavy if you think of it. You can have a criminal record against your name as the property practitioner together with the agency that you work for, and in event then all the people that's also having access to that data. But besides that, if you just take that away for a moment, reputational risk for your agency, lost in trust, bad reviews. So your footprint, your reputation as a property practitioner in a blink of a moment can go down the drain. And that is so hard to recover. I mean, you can pay a fine some way or another, but it's very difficult to really get your reputation back whenever you maybe unknowingly leaked some data purely because you were nonchalant about this whole compliance thing, and now you're sitting with a bad reputation as a property practitioner.
No, that makes a lot of sense, and that's definitely a very strong motivator for us to all stay compliant. Let's say, despite our best efforts, a data breach does happen. What should the landlord or agent do immediately after discovering the personal information might have been exposed?
Yeah, you see, this is the tough one where you actually have to step up and say, no, I know this happened. Okay, so how are we going to tackle this situation? And I think first and foremost is go back to your moral standards in being transparent and honest and say, well, this happened now. So instead of blaming or making excuses or saying, no, it's not my fault or whatever, just own up to it, and then you follow these steps. So the steps is firstly to go in to your information officer. So every single company, whether you're an estate agent, whether you're a sole practitioner, and then yourself is the information officer. Every company in South Africa needs to have an information officer. So that is the person within the company that's overseeing all the POPI compliance to make sure that your company is actually POPI compliant, or your agency. So firstly, you go to the information officer and you tell them, okay, well, I suspect, or even if it's a fact, this happened. The information officer then needs to obviously go to the information regulator by sending the email to the governing body stating, we suspect or we identified this information has been leaked from our company. These are the steps that we took to prevent it, but it still happened. These are the POPI compliance that we have in place or not. And rather be honest, there will be consequences either way. And then once you've done that, it's very important to go to the person whose details have been leaked and saying, listen, we identified a leakage in data of ABC. These are the data that has been leaked, and this is the measurements that we're taking to actually put a stop to it, etc., etc. So explain your process and really be honest. Just be honest, because imagine putting yourself in the shoes of your tenant, receiving an email stating, listen, your data have been leaked, which includes your ID number. You're going to freeze, and now you don't really understand the email that you read. There's a lot of ambiguity, and there's a lot of unclear, but what are you trying to tell me? Those type of things will make it even more worse. So rather just be frank, be honest, be open with the process, and make sure start with your information officer. They will go to the information regulator by emailing them and make sure that you are transparent with the clients whose data has been leaked.
That's really great advice, Marisol. Thank you. As hard as it might be, it definitely is best just to, like you said, be frank, be open with everyone, just so everyone kind of knows whereabout they're at. Alison, for anyone who's just starting out or who's feeling a little bit lost, what would you say the first key steps are to getting onto the right track for the POPI compliance?
As Marisol has said, every organization has an information officer, and if you don't have one, your CEO is automatically one. And I can tell you right now, CEOs don't have a cooking clue about what policies there are in the organization. Okay, they are big idea people. They don't care about compliance. They should be paying people to look over their compliance. So if you do not have an information officer who should either be your legal internal compliance specialist or your CIO or head of IT or both, you can appoint more than one, then please do that. Okay. It needs to be somebody who is actually in the organization. You can't outsource it to an external person. So it has to be an employee. And I highly recommend that the person who is appointed is not just appointed because that's so-and-so from finance and they've got the big book of policies. Okay. It needs to be someone who actually has been sent on training, who is given training about how POPI should work and is actually able to recommend organizational changes where needed. So you can't give it to a low-level employee who has no understanding of how the various mechanisms in the company interact. This needs to be someone who works under senior management or under your board of directors, who is trained and, like I say, has the ability to, sway how we deal with compliance in the organization. So this has to be someone with a voice to say, this platform is putting us at risk because it doesn't use encrypted codes to give people access, for example. So you can't give that to somebody who does not understand what that even means. So that's very important. It should be someone who has some sort of understanding as to what is POPI in practice. All right, and then also have a privacy policy in place. And like I said, that POPI framework. Somebody did ask about a PIA manual. All private and public bodies are required to comply with POPI and PIA. Nobody is exempt. And I will answer that question in more detail in the end as to what sections apply. But this is all online. Okay, so the information regulator has a fantastic website for both POPI and PIA, where it is literally like the dummy's guide to how to be compliant. And they are helpful. If you actually ask the information regulator for assistance, they will probably guide you. I remember when they came into fruition, they actually had training sessions that were free and open to the public as to what do we do, and how do you keep yourself up to date and compliant. Okay, so that's important. Information officer and having your policies. Now, policies that nobody knows about and nobody is trained on are useless. Okay, so if you have a policy as to how you collect, store, process, and destroy personal information, and not a person in the organization knows where that policy is or what it says, you're wasting your paper, you're wasting your time when you put those policies together. Policies shouldn't just be lip service, they need to be lived, cultural, embedded in the organization. So employees need to be trained on POPI. They need to be given a webinar, a refresher every year as to what our policy says and how do you deal with personal information. Because I can tell you right now, it's your more junior employees usually who will put your whole organization's data at risk, okay? Because they're not going to click that that's a phishing email. And they're going to click on it, and then your whole database is going to be breached. So that is very, very important, is to actually make sure that you train people on your POPI framework. Okay, make it fun, order some sandwiches, give people cool drink, like it's painful to sit through compliance, but it's important to train people on why. And I think we've given a few good examples like the identity theft as to why that is important. And something else is all third-party service provider contracts need to be looked at. And as Marizal said, have an agreement with that third-party service provider that they will adhere to POPI, to PIA, that they will adhere to lawful data collection and processing, and that if they're going to do something other than what you've agreed on the data that you've given them, that you get consent from that data subject. Okay, this is why we all get so frustrated with spam calls, because somewhere along the line, somebody thought they were very clever by saying, do you accept the terms and conditions? And nobody reads them. And I'm telling you now that the legislation is changing. People are not so easily, they're not so patient of that anymore. And the information regulator is also saying, nope, that's not going to be sufficient. You need to make sure your data subject gives that informed consent. All right, so I just want to speak about a few other things that people should do when the poo-poo and the paw-paw hits the fan. Okay, you wake up, you can't log into your database, it's been hacked, something has gone terribly wrong. You need to have an incident response plan. Okay, which means you need to have your information officer. You need to make sure that there are steps. People need to know how and who to report the data breach to, because it's not optional. You have to tell the information regulator, and you need to tell them exactly how it happened. And that's why certain companies will have insurance for these kind of data breaches, because it can be very costly for them. So you need to have an incident response. And you have to also have a data protection impact assessment. So this means that you need to make sure that you don't introduce risks into your organization, and you actually have someone who can analyze what those risks are. Access control, as I've said, please review your access control. Not everybody should have access to everything in your organization. And this is something we're seeing more and more with clouds, okay, working on the cloud. Very, very dangerous to give everyone and anyone access. Not everyone should have access to personal information. And your forms, like I've said, review those forms, make sure that you are only collecting what is necessary, okay? Not going to put you at risk. Also, just remember your information officer. Don't just appoint them and then say like, cool, your job, whatever, forget about it. Your information officers should be monitored, and you should be checking in with them if you are on a board or you're a CEO or someone overseeing that information officer. You should be asking them to develop and implement compliance plans and documents. So they need to actually keep you up to date with what we are doing. They should do it on an annual basis. And there has to be, I would say, like a POPI task team, okay? And you can call it a data protection task team. It doesn't matter, but it should consist of individuals who are high up enough in the organization just to make sure that everything you are doing is POPI compliant and that you're safeguarding yourself. Nobody wants to have a data breach, okay? It happens way more often than you think. And remember, as an agent, somebody mentioned WhatsApp on their phone. That's like a gold mine of data that you can put at risk there. So just make sure you're also thinking about how you're dealing with personal information on employees' personal cell phones. Very important, especially in South Africa, where cell phones get snatched all the time. So those are just a few things that I'd say, look, if you're going to do nothing, just do what I've spoken about now in this last question. And if you don't want to do it, there's plenty of attorneys, SPL also does it, who will literally give you the documents and work with you to make sure your organization is compliant. So if compliance is like a really bad word in your head and gives you the heebie-jeebies, it's fine. There are so many companies and law firms who offer this service. And when the information regulator comes knocking, you can actually sleep at night.
That's awesome. Thanks, Alison. I just also wanted to mention, because we're working with agents and agencies, so an intern agent has the highest turnover rate. Like, that's why principals don't enjoy, they enjoy building agents and interns up. They don't enjoy it when they leave so quickly. So, so what a good idea for them as well is to include whatever the policy and procedure is, and even just like a short video of the training you did for your staff. So say you introduced POPI to your agency, you recorded it on Teams, and then you kept that recording, then put it in their induction pack. So no matter who's joining, they are very quickly brought up to speed before they even start WhatsApping or texting anybody for information. So I just thought that was quite a good idea. We do a lot of inductions as well for agencies, and it is good to keep it in the pack. And then where you mentioned possibly doing the training once a year, which is normal for a normal company. I think with agencies, if you're having your sales meetings, I know normally every Monday, but at least once a month, bring up like, guys, can I double check this? Where is that saved? Just little spot checks to make it a little bit more of an active thing that you never know when it will be checked internally. And that's not to like blame anyone, that's to get a system working, because if a system's not working, it just means it needs to be fixed, but you won't know if you don't test it. So yeah, just a few little tips there.
100%. So yeah, like you've said, Courtney, any new employees coming in, definitely they have to be kept up to date. And I think that's what we were speaking to, is making compliance part of your culture. And if you have good systems, compliance is easy. But if your systems are a disaster, then compliance is everywhere. So getting those IT systems in place is going to help your compliance greatly.
Yeah, no, that's lovely. Thank you.
Definitely. Well, I think that covers our last question then. So thank you both so very, very much. Thank you, Courtney, as well. I just want to share my screen quickly. I'm going to pop it over to a contact us page for SPL attorneys. So you're able to contact Alison and Marizel if there's any questions that you have. I hope I share the correct screen. So there we go. If everyone can see it, if you want to just pop a reaction in the chat box, thank you all so much. But it has been an absolutely incredible session. We've really, really loved it and enjoyed it and learned so much. So we appreciate your time very much. Thank you all for joining us.
Now we just head over to some questions that were in the chat.
Courtney, would you like me to answer the few that are on the chat?
Thank
All right,
you.
perfect. So Henry says, must the business provide their PI manual or policy on their website, and under what law? It is under the Promotion of Access to Information Act, and I'm actually going to share a link in the chat box. There is a fantastic access to information.co.za webpage. It is run by the information regulator at section 14 and section 51. Nobody is exempt. Okay, so if you have to comply with POPI, you have to comply with PIA. The two of them are inseparable. Like I've said, they're husband and wife. So if you can't remember which ones go together, just remember POPI and PIA go together. All right, so how often can a landlord request for updated personal information? So Deline, that is more going to be your FICA KYC checks, which is something else that we do assist our clients with, is staying up to date in FICA compliance. But I would say at least once a year, or whenever there's any major change in the relationship, you must redo those KYC checks. If they're getting married, the husband's moving into the property with them for whatever reason, if there's any sort of major change, just make sure to do your FICA KYC and to get any additional information. So it's not just a once-off thing. If you have a long relationship with a client and it's going to go on for more than 6 months or a year, just make sure that you keep up to date with those FICA KYC checks. Okay, so that's more of a FICA question, but nevertheless, it is important to note. Romario, thank you for bringing up the credit checks that are standard and rental credit checks. I know there are platforms that do the rental credit checks. Some landlords don't have access to that one, so they do a full credit check. And like I was saying, then it pops up on your credit profile, and then tenants get quite aggravated. So just make sure that the platform you're using, you have consent to do that exact credit check as well. And if there are any implications of doing that check, just make sure the tenant is aware as well. Okay, Tracy asks a really nice question. I think it speaks more to the Consumer Protection Act and direct marketing than to POPI, but it's nevertheless important because all of this legislation interplays. So Tracy asks, can we send a broadcast to clients who are already saved onto our phones? And the answer is if you have their consent. Okay, so have they consented for you to keep their numbers? And is there a reasonable reason why you have those numbers? Okay, do you have a current relationship with them? Are they a current client? And what's important is if you are going to send a broadcast, add that opt out, okay, to your message. So say if at any point you would like to opt out of these broadcast messages or opt out of this direct marketing, please let us know and we will remove you from the database. And then actually remove them from the database. So many companies get this wrong, where they tell you you can opt out, you can sign out. We don't want to keep your information, and they never, ever actually delete your information. So there's been some very interesting developments with the CPA and direct marketing in particular, and it is becoming a lot more stringent, and it ties in with that POPI aspect of protecting people's information and giving them autonomy to consent as to how that information is actually used. Okay, so Lynn has quite a lengthy question here. Can you confirm what the law is with estate agents having access to information on residential homeowners? For example, an agent calling to find out if you want to sell your property. Once again, direct marketing. How did you get that information? Did you get consent for that information? And when you contact that person, you need to make them aware of, hi, we got your number from a so-and-so open day or from a so-and-so convention. You signed up to get marketing from us. If at any point you want to opt out, please do so. So I just want to speak to this direct marketing thing, because if a client tells you they don't want to receive marketing information and you continue to bombard them, they can actually follow regulator recourse against you. So it's really not worth it. Okay. Then I also see an agent advised they have access to title deeds from a municipality. There is a lot of personal information on there, which is a concern. They know if we have a bond with which bank, how much we paid for the property. It's a question asked to me all the time, and I'm commercial. So of course you can hold sensitive information. That's, you know, what POPI says. You can collect it, but it's how you've collected it, and it's also what you are doing with that information that distinguishes whether you are in lawful possession of that information or you are not. Okay, so that's an important distinction to make. You can hold very sensitive information. Your doctors do, okay? They know everything that is personal about your medical records. But they are entitled to do it because of the relationship they have with you and the services they need to render to you. And it's no different from agents. If it is relevant and necessary for the purposes of that transaction with that client, you can hold on to that information. But as soon as that information becomes unnecessary or it's outdated or you're no longer required by law to store it, you need to make sure that you destroy that information securely and that you keep that information under lock and key. Nobody can just get access to that. Okay, if it's all the stuff on a WhatsApp chat and it's on your personal phone, maybe not such a good idea. Try and have it on a secure database instead. Kathy asks a question here. What if tenants don't consent to a yearly credit check? And I am assuming, Kathy, that these tenants are renewing a lease agreement year on year. I think that that's not so much a POPI question because you are entitled to a credit check when a tenant undergoes vetting, and renewals are no different to that. Okay, you are entitled to see if they can still afford the property and it can be renewed. But then the landlord's discretion is really there to say, well, it's part of our vetting process and we are entitled to not renew the lease should you refuse a credit check. And I just want to speak to, I know we spoke in depth on our other webinars about credit checks, but it's generally a red flag if a tenant doesn't want to give you a credit check. Something has happened. Maybe they've got a judgment against them or there is an account that is hugely in arrears. So there's generally some sort of red flag going on there. And I can tell you right now, they're probably using POPI as an excuse to not give you that information, which they can't rely on for the purposes of that transaction.
That's absolutely perfect. Alison and Marisol, thank you so much again. I've seen a couple of messages in the chat just with regards to the recording. Don't worry, there will be a recording of this session. It'll be live on our podcast page in about a week to 2 weeks, but we'll also send out the recording to all those that joined today. So thank you all so much. We've had an incredible session and very informative. I've learned a lot from this session. We appreciate your time and thank you everybody for joining us today. Have a wonderful afternoon.
Thank you so much.
Thank you so much.
Take care, everyone.